What is voluntary consent, particularly within the context of law or business law? To start with, voluntary means in itself knowing and willful. That is, a person understands what they are consenting or agreeing to, and they are doing it willfully without any level of coercion through any means or source. Now, what are some common methods or means of coercion that will interrupt the voluntary nature of someone's agreement or consent? To start with, force. So it is implied for something to be voluntary that there's an absence of force there, whether that's physical, mental, emotional, etc. Also, if someone does something based upon some level of undue influence or power that someone holds over you, you're making that decision not by your own volition, but based upon the influence that is inadvertently or intentionally being exercised over you. And then there's duress, and that is the knowing, willful act of threatening or proposing some level of negative outcome or harm in the event that someone does not do what you tell them to do. And if a level of duress, such as blackmail or threat of physical force, is present, once again, your actions, your decision making is not voluntary. It is unduly controlled by the actions of someone else. So again, in that situation, you do not have voluntary consent. When does voluntary consent become important? In many situations and scenarios, certainly under criminal law when it comes to whether you actually did something that was a violation of the law, whether you can knowingly give someone consent to do something to or with you. But in business, it primarily applies in contracts because the elements of a contract are an offer, acceptance, and then the exchange of value, consideration. Both parties must understand, have a knowing appreciation to what they are agreeing, such that there is a meeting of the minds between the parties. Now, if someone makes an offer and the other party consents to that offer by agreeing to it, they must have done so voluntarily.